Mm.
Traps and throw backside, try to trace my tracks. Hope you do too. Long range and short change, I find everything strange. Hope you do too. I'm gonna learn me my lesson and move on. I'm gonna keep on loving till the loving's gone. 'Cause I can see that sometimes we get somehow strong, and I do it all alone. Did you? High hopes and short ropes, I try to change my scope. Hope you do too. Strong nights and fist fights, I'm down by the bright lights. Hope you are too. I'm gonna learn me my lesson and move on. I wanna keep on loving till the loving's gone. I'm gonna learn me my lesson and move on. I'm gonna keep on loving till the loving's gone. I'm gonna learn me my lesson and move on. I'm gonna keep on loving till the loving's gone. 'Cause I can see that sometimes we get somehow strong, and I do it all alone. Did you? Did you? Did you?
Hi, I'm Jimmy with Professional Home Staging and Design, and for over 15 years we've been helping real estate agents, homeowners, and investors make more money selling homes in the Raleigh area. For a minimum investment, you get a maximum return with home staging. It's proven that homes sell in quicker time and for more money. So again, we're Professional Home Staging and Design, professionalhomestaging.com.
Hi, my name is Adam Schneider, and I'm with Oakwood Lending. You can reach us at oakwoodlending.com. And I've been with TREIA since 2012. I'm located in Raleigh, and I bought over 150 houses, so I've got plenty of experience to help you if you need a second set of eyes. When we do our loans, we don't require a loan application fee. We rarely require an appraisal. We don't charge draw fees on it. We have a quick turnaround time, usually responding within 24 hours. We're okay to do a small loan. Send a loan application. We do loans in North Carolina.
Let me just say, everyone, there are CenturyLink outages all over in Raleigh and surrounding tonight. So if there's problems with this meeting, or if you all are having problems, that's probably what it is.
Heartaches on long breaks, I learn from my mistakes. Hope you do too. Heart turns and slow burns, the wounded heart still earns. Hope you do too. I'm gonna learn me my lesson and move on. I'm gonna keep on loving till the loving's gone. 'Cause I can see that sometimes we get somehow strong, and I do it all alone. Did you? Steal traps and throw backside, try to trace my tracks. Hope you do too. Heartaches on long backs and throwbacks. I try to trace my tracks. Hope you do too. Long range and short change, I find everything strange. Hope you do too. I'm gonna learn me my lesson and move on. I'm gonna keep on loving till the loving's gone. 'Cause I can see that sometimes we get somehow strong, and I do it all alone. Did high hopes and short ropes, I try to change my scope. Hope you do too. Strong nights and fist fights, I'm down by the bright lights. Hope you are too. I'm gonna learn me my lesson and move on. I wanna keep on loving till the loving's gone. I'm gonna learn me my lesson and move on. I'm gonna keep on loving till the loving's gone. I'm gonna learn me my lesson and move on. I'm gonna keep on loving till the loving's gone. 'Cause I can see that sometimes we get somehow strong, and I do it all alone. Did you? Did you? Did you?
Hey everyone, thanks for being here tonight. We're going to turn it over to Stephanie for some announcements, but before she gets started, we are doing Who's Got What before meetings now. So if you have anything you'd like to share, something you want to offer or something you need, drop us a note in the chat to the host and we'll let you do it. And just like to remind you that with our new structure in place now, we have a bunch of new programs we're offering. We just finished rehabbing and selling a house, which was awesome. And we're getting ready to start a mentorship program. We have some experienced members signed up to be mentors. And without our new structure, none of this would be possible. So thanks for being here. And it's over to you, Stephanie.
Hey, again, thank you all for being here tonight. Still a little sad. We're still stuck in Zoom world, but they did loosen it up a little bit with 2.5, so maybe we're working towards the right direction, and hopefully we'll maybe be able to meet in person sometime soon. But until now, we do have several networking opportunities. You can check out our Facebook group. We have Facebook networking, so make sure that you check that out. We are trying to keep a little bit of networking going, so if there's anything that you have that's good news that you want to share, type it in the chat box. We can unmute you, that way you can tell us about it. It can be, did you just have a great rehab? Did you just have a grandbaby? Are you looking for a roofer? Anything like that, just type it in the chat and then we can unmute you. We can't see everyone, only we can see the messages in the chat, but we'll announce it to everyone and then we can unmute you and let you talk. The board members on the meeting tonight, we have Kathy Russell, Jackie Richards, and Leslie Ortiz. And let's see, upcoming meetings that we have. I'll make sure that you're always checking the calendar. We have this is the only meeting for this week, but next week we have TREIA North, new investors, TREIA Fayetteville, and experienced investors. Just make sure you check the calendar. And then we also have our monthly meeting. Who is the speaker for the monthly meeting this month?
This month, Steph, we have the king of creative financing, which would be Larry Harbolt. He's right here in North Carolina, so he's real familiar with the local markets. And if there's a way to do a deal, he's gonna let you know how to do it. So be on the main meeting. That would be the third Tuesday, which would be the 22nd. No, that'd be the 15th. We got 5 weeks in this month.
Yeah.
That's weird. Anyway, on the 15th, the evening, the monthly meeting, be Larry Harbolt, and you want to check in with him because he's got some really good info. Really good.
Okay, great.
And that's it.
All right, great. We are also at the beginning of the meeting, we have the slides that go through. We always have a member spotlight. If you would be interested in being the member in our member spotlight, feel free to reach out. You can send us a note to TREIAprojects@gmail.com, and they can tell you how you can participate in that. Just another great way to tell people about yourself, so you put yourself out there and people will get to know you a little bit better. They're also always looking for TREIA volunteers. If you're interested in volunteering, please feel free to reach out. Volunteering is how I honestly have built my business. I've met so many people through TREIA, and I would have never ever done that had I not volunteered. I've been doing it now for several years. I've met lenders, I've made friends, I've gotten deals. So it's just something to always think about doing. I truly think it's just like a great way to help build your business. Kathy also talked about the rehab project that they just finished up. If there's other like speakers or events or things that you would like to hear about, just feel free to reach out. You can also send that to TREIAprojects@gmail.com. They're always trying to think of new ideas and new speakers. And sometimes, we're in our way of thinking. So if there's somebody specific for South, or maybe a main meeting, if there's someone specific you'd like to hear, or a topic, sometimes we have a hard time trying to think of new ideas. So it's always great to hear if you have a great idea. So please email us and let us know if that's something if you have a great idea. Did anybody put anything for who's got what?
Yes, we have one. Jackie has a slide she's going to put up, and this is from Jeremiah Fennell with New Western. And Jeremiah, if you give me a minute, I'm going to find you and unmute you so you can tell us about this. Sorry, just takes 1 second.
Can you see the slide, guys?
Yep.
I can see it. Yeah,
Yeah, we can see it.
Okay, Jeremiah, you're up.
Perfect. Welcome. My name is Jeremiah Fennell. I'm with New Western Acquisitions here in Raleigh. We have a few properties that I want to point out this month. Both the Fayetteville properties, they are turnkey with tenants in place. They've been around for 5 years, and the one on Coley Drive, they've been there for 7 years. It's very close to Fayetteville State. The Durham property, the one on Park Avenue, is a single-family home in a great neighborhood. And then we also have our Prince Street one, which is fantastic. But my number is 919-636-3669, and I get a lot of off-market investment properties. So.
Thank you, Jeremiah.
Of course.
All right, Stephanie, I turn the meeting over to you now.
Okay. Any other announcements before I turn it over to James and Stephanie?
Not from me.
Okay.
Just a welcome. We have a lot of new members that are in attendance. So welcome to everybody that has joined. We're thrilled to have you. And if you're a new member, put your name in the chat so we can wish you a happy first meeting. That's it.
All right, great. Okay, so next up, we have our speakers for this evening. We've got Stephanie Diatri and James Oliver from Hatch, Little and Bunn, and they are going to talk to us tonight about how to keep ourselves out of real estate jail and maybe even some normal jail for those white collar crimes. So I'm going to hand it over to them. They both have great experience. I've worked with both of them. I think everybody's heard me talk about how Stephanie has bailed me out of some sticky situations. And then I've also worked with James as he's helped with some closings as well. So I'm gonna hand it over to the both of you, and it's up to you. It's turned over to you. Okay.
We take that
Hey,
slide
thanks
down,
everybody.
Jackie.
Can everybody hear me okay? I can see some of you on the screen. So I'm Stephanie Diatri. I'm an attorney over at Hatch, Little and Bunn. This is my law partner, James Oliver.
Here.
Sorry for the great graphics this evening. I'm going to let James talk first. So I handle all of our residential real estate litigation in the landlord-tenant context. So I've probably handled 20 or 30,000 evictions over the course of my career. I started working at Legal Aid, representing low-income housing, tenants on HUD properties and Section 8 vouchers, and essentially keeping them in homes, which is, I'm sure, the exact opposite of what a lot of you want right now. But it's a good background to have because I know almost exactly what the other side is going to argue. I mean, occasionally they sidestep me a little bit, but for the most part, I can typically anticipate a lot of the defenses and arguments and claims that they're going to raise. And so I handle mostly landlord tenant work and some other real property litigation. We've got a real property litigation section at my law firm. And so I've got other lawyers here who also handle real property partitions and things like that. And then James is sort of our transactional real estate lawyer. So he handles all of our residential closings and commercial closings. He does both. And he also does a lot of like business formation and things like that. And so I wanted James to talk. I'm not sure if any of you were at the last TREIA meeting where I spoke before, and I kind of spent a lot of time talking about evictions and the landscape, and obviously a lot has changed in the last year or so since I've met with you folks. And so I wanted to cover the sort of the changing landscape of evictions and the courts and how everyone is interpreting the CARES Act. And then James is going to talk briefly about kind of setting up your real estate business in a productive way to start with. You know, there's no right way necessarily, but he's going to talk a little bit about business formation and tips and tricks for just things that you need to consider. What I would ask is, I'm sure a lot of you are probably going to have questions. And so if you have a question after James is, you know, as James is speaking, just send it into the chat and we'll take a look at it and I'll try to have James answer some questions. And then after he's done, I'm going to pop on and I'll ask or I'll add with a lot of the evictions and changing landlord landscape. So James, I'm going to turn it over to you, and
all right,
there you go.
Thank you very much. We bombarded Stephanie in her office. We got kicked out of our conference room because the mediation went late. So hopefully this will go off okay. I do not go to court. If I go to court, it's a bad thing because I'm a transactional attorney. I mean, somebody did something wrong. So I do handle most of the closings in the office, residential and commercial. My litigation is usually limited to foreclosure work, and that's actions before the clerk, which is a little different than normal court proceedings. But I represent a lot of small business owners and a lot of property owners. And so I thought I would maybe just give some pointers on opening an LLC. Many of you probably already have LLCs, but those of you that are considering it, I'll kind of give some general guidance on how to do that, why you would do it, the pros and cons, and we can kind of talk through some things. And then if you have some questions, please feel free to let me know. So the two big reasons for an LLC, other than, you know, it looks nice to have an LLC, right, is that taxes and liability. And I try and stay away from taxes. I'm not a CPA, but it's a good reminder that when you're thinking about an LLC, if you probably are at the point where you're not doing your own taxes, and so your accountant should be on board with this, and they almost always are. And most real estate holding type of companies, most CPAs are going to suggest you do an LLC instead of a corporation. You typically only do a corporation if you're going to have payroll. And most of our LLCs that own properties do not have a payroll account. And even if you do, and it's not that sophisticated of a payroll account, you'd still probably go the LLC route. LLCs are more flexible. You have a lot more options as far as how you manage and run it, and executing documents and things like that are just easier done under the LLC. One of the pros about a corporation is, for some reason, the Secretary of State charges half the annual filing fee for a corporation for some reason. I've never been able to find out why they pick on LLCs that way, but they do. The annual fee for an LLC is $250. Does that sound right, Stephanie? Or $225, the annual fee, and a corporation is about half that. So, but again, most times your accountants, I think, are going to suggest for a real estate holding to go the LLC route. So then the second big reason why you do an LLC is for liability. If something, God forbid, terribly tragic happens on one of your properties where there's some real liabilities, someone dies or is greatly injured, then the asset whatever's in the LLC, those assets are the only things that someone should be able to come after you instead of coming after you personally. And so I have some clients who create LLCs for just one property. That seems to me a bit overcautious. But if you had one problem property, or you had a duplex or multiplex that had a lot of students, or maybe there's just you're in an area where the liability could be greater, maybe you bifurcate that in its own separate LLC. But in any event, it takes it out of your name personally, and should protect you from being sued and having your personal assets attacked if you were found negligent or culpable in a lawsuit. And the reason why I say should is because there are ways a plaintiff can still pierce the corporate veil, and that's what we call it when a plaintiff comes after you and says, we're not just going to look to the LLC, we're going to come after you personally. And that's because there's some certain things that you can do, which is more than just negligence. If you actually do something completely illegal, that's going to take you out of the corporate protection. And also if you don't act as a corporation. So if you don't title the properties in the name of the corporation, you don't set up a bank account, you don't have tax returns in the name of a corporation, you don't have your leases in the name of a corporation, you don't take checks from tenants in the name of the corporation. These are the sort of things that you want to do after you create the LLC, so that you're functioning to the outside world as an LLC, so that if something does come up and you are attacked, you're sued, that they're not able to pierce the corporate veil. So setting up an LLC I think is very easy. Now we file with the Secretary of State electronically. The filing fee is pretty minimal for an LLC. It's $125. Most people I've been paying the extra $100 to expedite it. Ever since COVID, for some reason, the Secretary of State is taking 2 to 3 weeks to file an LLC. I don't understand why, because they're apparently, many of them are still working in the office, and those working from home, you would think they would still be producing at the same level. But in any event, it's taking longer, so most people don't want to wait the extra 3 weeks. So that's the filing fee to the Secretary of State. The document is called the Articles of Organization. We typically like to list the members, and that's how you own your ownership in an LLC, is through a membership, not as opposed to a corporation, which is a stock. And under North Carolina law, all members by definition are managers. So, and as a manager, you have authority to sign documents and bind the LLC. So on the actual articles that we file, we identify the member manager. And the reason why that is important is that way, when you are dealing with a bank or lending institution, opposing parties or whatnot, it's very easy for them to go to the Secretary of State and validate that you have authority to act and sign documents on behalf of the LLC. The other part about an LLC, as far from a cost standpoint, the initial setup, and obviously from your CPA, will be tax returns. Once you start taking money through an LLC and then spending money through the LLC and generating money, income through the LLC, you're going to file a schedule, which will be part of your tax return. Almost all LLCs and most corporations are pass-through taxation, which just simply means the taxes are paid by you personally, but it comes in as a schedule. So instead of this rental income showing up on your personal tax return, it shows up on a schedule that's pulled into your tax return. And obviously that's going to probably be more expense from your CPA. Although I find once you get the CPA set up and your corporate books get set up, going in the future, those costs are minimized. Again, unless you keep increasing, and which is a good thing, adding more properties, then obviously your CPA might start charging you more, particularly if you have more transactions coming in and coming out. So let's assume you've made the decision to create an LLC. You filed it. The LLC is now active with the Secretary of State. Now what do you do? Well, you go to the IRS and you get an EIN, which is basically the employer identification number. It's the social security number, if you will, for your LLC. And with that, again, that will be on your schedule for your tax return. And with that, that's when you create your bank account for the LLC, you will use the EIN instead of your social security number. And that means the LLC, the IRS can track your LLC as a non-disregarded entity, and therefore any income to the LLC can be tracked. There shouldn't be any withholding then if you sell property under the LLC, because it's the IRS, everything is again going through your EIN. So you've created your bank account, you've gotten your EIN from the IRS. Now the next step, the big step, is once the LLC is created, is to actually move your properties into the LLC. If you continue to own the property as an individual, you've wasted your time and money on the LLC. So that's easily done with a deed. If all of your properties, and if you've got 10 properties and they're all in Wake County, we can do one deed and we just add 10 legal descriptions from yourself and your spouse, titling the properties and moving it as you would be the grantor on the deed, moving it over to the LLC, and then the LLC will now own the property. Once you do that, there are a couple key important things you need to consider. Your insurance on the property, your hazard insurance, your premises liability, that insurance is previously in your name individually. Once you move it over to the LLC, it's very important you contact your insurance agent and let them know that you've changed the title to the property and the insurance should now be under the LLC. If something, God forbid, happens to the property and you need to make a claim, if the ownership does not match up with the insurance policy, you're going to have issues with collecting on the insurance. The other issue to be aware of is if you have any financing on your properties. When you move the property from yourself individually over to your LLC, technically you're breaching most deeds of trust, because most deeds of trust have a clause in there that if you transfer the property, it's a default. And in theory, they can foreclose. Now, I say in theory because I've been doing this now 24 years. I've never had a bank foreclose on a property merely because it was transferred from someone's name individually to their LLC. So long as you're making payments. I mean, that's goes without saying. They will be quite insistent on that, and they will foreclose if you don't make payments, obviously. But just moving it over, and I just have to caution people when they do it that technically you're violating the deed of trust. What I do on my deeds, so that deed, again, where you've signed transferring the property over from yourself individually over to that LLC, I include with the legal description some language that says this conveyance, so from myself, I'm conveying the property from me to my LLC, this conveyance is being made specifically subject to the deed of trust, and then I put in the recording information, book and page for that deed of trust. And my thinking there is if a bank should become upset that I've done this, I can show them the deed and say, hey, I'm not trying to avoid the deed of trust. My LLC, I simply moved it over for tax purposes, and I'm clearly acknowledging the deed of trust on the face of the deed. Again, I've not had an issue with this before, but it's just something to be aware of. And worst case scenario, if for some reason this particular bank should get extremely upset that you've done this and moved it over to your LLC, the remedy is we just move it back. So we would avoid foreclosure. So it's not the end of the world. We've spent money creating the LLC and doing all this, but it's not something we can't recover from. But again, I've never had an issue with the bank so long as you're performing under the loan. If you are considering doing this, or you have properties already in an LLC and you're thinking about doing some refinancing or do some purchase money financing or whatnot, it is something to consider when you look for your lender. If you go to a bank that's more business oriented, community type banks, those folks are set up to do loans in the name of the LLC. Now, of course, they still have you sign a personal guarantee, so you're still personally going to be on it. You can't get away from that. But because the loan itself is originated in the name of the LLC, then there's no violation. You have not breached the deed of trust because you're not changing it from the borrower as yourself individually to your LLC. And so most community banks, anybody who has what I call portfolio loans, where they hold the loans in-house, they're not selling them out to Fannie and Freddie on those type of loans, they're not going to have an issue doing the loan actually in the name of the LLC. So just something to consider there when you're choosing your lender. That's kind of my primer on LLCs and how you can do that, and I think very easily. And it's usually, if you're asking my advice, at what point do I do an LLC? If I had just one rental property, I probably wouldn't. Once I start getting 2 and 3 and 4, then I would definitely start considering it. And again, if I had a property that was problematic from a liability standpoint, I certainly would. So hopefully that was helpful. If I can answer any questions, let me know, and I'll turn the floor back over to Stephanie.
Okay, great. Thank you. Does anyone have any questions for James before he walks off? Are there any questions in the chat?
Do you want to click on the chat? Sure.
I see 2 things on the chat.
I think we should just keep going, Steph. We'll check with
Okay.
Kathy.
Okay,
Yeah.
all right, cool.
Yeah.
All right.
There she is.
All right. Now for the grand finale. I was going to spend a lot of time. Can everybody hear me okay, hopefully? I'm a loud talker sometimes. So
Yep.
I was going to spend a lot of time talking to you guys about the CARES Act and kind of the general eviction landscape in the last, several months. However, I think some of my time tonight should probably be focused on what is happening literally right now as I'm talking and as we're having this meeting. Some of you may have heard by now, the Center for Disease Control. Let me back up just a moment. Stephanie, can I share my screen? Is that possible?
Leslie can answer that better. Can she share her screen? Hey, I can't hear you, Leslie.
No, she should be able to. We have to switch her over.
Because you're listed as a co-host.
She's a co-host, so Stephanie, you should be able to just hit your button at the bottom there.
Yeah,
okay,
there should be a
awesome.
button at the bottom.
I'm going to do that now and
Yeah,
work with
way
you
you
here
go.
just a little bit on the technology.
For sure.
All right.
There you go.
There we go. All right, so
Yeah.
everybody should be looking right now at a PDF type thing.
Yeah.
All right, so many of you probably recognize this. I don't know how many of you have actually read the CARES Act, but what I've got pulled up right now is Section 4024 of the CARES Act, which was the temporary moratorium on eviction filings. I'm going to come back to this one, but that's what that is. The Section 4023 probably doesn't apply to many of you, but I'll cover that at the very end as well if we've got time. This is a North Carolina court memo, which I'll share in a minute, and then this is an executive order. I'm going to start with this one. Many of you have heard, probably, that President Trump entered an executive order on August 8th, 2020. Basically, he promoted to the public that he was going to do something with evictions, and he wanted to continue to hold evictions because the federal, Congress had not extended the CARES Act. And so the CARES Act, there was a very specific 120-day period within which you couldn't really do anything if you had a federally backed mortgage, so Fannie Mae, Freddie Mac, veteran loan, etc. And so he came out and said, look, it's expired, and I know I can't really do much, but I'm going to direct my agencies to do something. Well, unfortunately for a lot of us, one of his agencies did do something today. So the Center for Disease Control, about an hour or a couple hours ago, published essentially a directive, and I'm going to pull it up on my screen if you give me 1 second, just because this is all happening very quickly. Let's see. give me 1 second, sorry.
Mhm.
Here we go. All right. All right. Hopefully everybody can see this. All right. So a little while ago, they entered an agency order that is a quote unquote temporary halt in residential evictions to prevent the further spread of COVID. I literally found out about this about 30 minutes ago, so we're going to kind of walk through this a little bit together, but it's important for all of you because unlike the CARES Act, it applies purportedly to every landlord. And that is the unfortunate part about this. Essentially, I'm going to skip through the background, but there was a lot of discussion with the original CARES Act about, you know, whether or not you could file certain evictions and whether or not you could evict people for criminal activity and whether or not, you know, it was really just designed to help people financially because it was initially designed as a financial incentive bill. But a lot of the legal aid advocates and tenant advocates have always argued that the whole point of the CARES Act was to prevent the spread of people in the community, meaning we don't want to displace residents from one house and put them, you know, on the street or having to move around, because the simple movement of people, the government and legal aid has argued, is what actually increases the spread of COVID. I would argue other things increase the spread of COVID way more than this does, but you know, who asked me, right? So this is kind of the background of the CDC. They're basically saying from a public health perspective, we believe nobody should be moving around unless they absolutely have to, because that's going to contribute to the spread of COVID. So here's the text. It says, under this order, a landlord, owner of a residential property, or other person with and person really is just later defined as a corporation, you know, LLC, whatever the case may be. In theory, a trust as well, if some of you have properties set up in trust, with a legal right to pursue eviction or possessory action. So a landlord in that context shall not evict any covered person from any residential property in any jurisdiction to which this order applies during the effective period of the order. This allegedly is going into effect as soon as it is published in the Federal Register, which according to a lot of news outlets today, I have no magic ball here, but that is expected to be later this week. And so as soon as it's published, it becomes effective, and the covered period that they reference in this order goes until December 31st of this year. And so essentially the CDC is saying, if you fall under this, you can't evict anybody until after December 31st of this year. Now, the sort of positive things about this, even though I recognize it's very difficult to find positive things in not evicting people for 12 months. However, sort of a side note, the CARES Act had a lot of inherent problems. And that's what I was going to spend the bulk of my time talking to you about, because legal aid has argued repeatedly that forever, indefinitely, from here until infinity, you have to send 30-day demand notices for non-payment of rent, if you have a covered property. And the covered property in this agency order is actually different than the covered property, covered tenant in the CARES Act. Let me just flip down and I'll kind of show you what it talks about. So basically a renter has to provide a declaration to their landlord. And I'm going to scroll down to show you. Here's the declaration. So a covered person is any tenant that, or lessee or resident of a residential property who provides, this language right here is very important, provides to their landlord, the owner of the residential property, which, for any of you who are rental agents, you got to double check with your owners as well, because you might have a tenant that's got a direct line to the owner, And so they might contact the owner about this, and you got to make sure that, you know, they haven't received the declaration. Any other person with a legal right to pursue eviction, they've got to provide a declaration under penalty of perjury indicating that the individual has used best efforts to obtain all available government assistance for rent or housing. The individual either expects to earn no more than $99,000 in annual income or $198,000 if filing a joint tax return, which it's a lot of money, so there are going to be a lot of covered people. Was not required to report income, so, you know, a very, you know, well, still a decently large subset of people probably, or who received a stimulus check. Well, a lot of people received a stimulus check, but the people who received a stimulus check likely earned no more than, you know, 99 or somewhere a little bit over that, because they prorated some of it. I don't know how much of you followed that, but usually they're going to be in this $99 to $120,000 bracket. That's a lot of people in America. In addition to that, they've got to also attest under penalty of perjury that they're unable to pay the full rent or make a full housing payment due to substantial loss of household income, loss of compensable hours of work or wages, a layoff, or extraordinary out-of-pocket medical expenses. And that's also defined. What I'll do is after this thing is over, I'm going to email Stephanie Anson a copy of it, and so that way she can circulate it. Stephanie, do you have a way to circulate that to everybody?
Yeah, we can get that out to everyone.
Okay, I'll get this to her in a few minutes, and then y'all can circulate it so you can actually read this order. And I would encourage all of you to do so as quickly as you can. So they're using, you know, they've also got to attest that they're using best efforts to make timely partial payments that are as close to the full payment as the individual circumstances may permit, taking into account other non-discretionary expenses. This is a very important clause. Some of you have good leases, some of you had bad ones. If you have the North Carolina Realtors Association, you may think you have a good lease. It's not a fantastic lease agreement, no offense to the Realtors Association. There are a lot of things in there that I think are not very landlord friendly. I think the intent behind the Realtors Association was to provide sort of a middle ground lease that wasn't super landlord friendly or super tenant friendly. And so as a result, you're not getting all of your protections. If you have that, you need an addendum to that. I mean, of course, welcome to reach out to me. We could talk about that another time, but I would strongly, whether it's me or some other lawyer, you really need to have an addendum to the realtor's lease if you have one, or you have that. If you have the Apartment Association of North Carolina lease, that's a good one. If you have the National Apartment Association lease, that's a decent one. If you have one you got on the internet, you might as well not be a landlord. I'm sorry if that sounded harsh or critical, but leases that you pull up from Staples or online, if you're going to be a solid investor and you're going to, you know, make good, smart real estate decisions and expect to make money, you really need to get a good lease, because your lease is sort of the bedrock of what you can do with your property. If you want to evict somebody, if it's not in your lease and you don't have clear language and you've got some crazy cure period in there, like a lot of these online leases make you do a 10-day cure period for rent. You don't necessarily need that, and that can be removed. And so long story short, if you have a lease you got online, I would strongly encourage you, again, whether it's me or some other lawyer, I would strongly encourage you to get a better lease agreement. I've spent the last probably 6 years of my career working on a lease that is probably 18 pages in length, and it's pretty detailed. So again, mine or someone else's, get a better lease agreement. The reason I bring that up is because this line, the individual is using best efforts to make timely partial payments. Well, North Carolina passed a statute, I think 2014 or 15, that said, if you want to take partial payments, you have to have a provision in your lease that says you can take partial payments. Because if you don't have a provision in your lease that says you can take partial payments, then if you do, you waive your rights to evict or to go after the tenant for that amount of money, essentially, especially, or the bulk of that being you can't really evict somebody if you take a partial payment. So if I have a tenant who hands me $1 and I'm owed 10,000, I can't try to evict until the next month. And so this is really important because the federal government is saying these individuals, these covered, tenants, have to make partial payments. Well, if you're a landlord that's got a bad online lease agreement and you don't have a clause that very specifically carves out the ability to accept a partial payment, then you're waiving your right to evict anyway. And so, food for thought, but this is an important just point I want to bring up about leases. And then the other thing that the person would have to declare under penalty of perjury is that the eviction would likely render the individual homeless. Of course, everyone is going to say this. I mean, of course an eviction is going to render them homeless, or force them to move into and live in close quarters with some sort of shared living setting or, a group of people because they have no other available housing options. You can go and read, and if I have an opportunity in the next few days, I'm supposed to be leaving town on a very much needed 2-day break in a couple days. But if I have a chance, I'll try to bullet out some of these things and send it out to Stephanie as well, maybe even beginning of next week once we know more about when it's docketed in the Federal Register. But please read this because this likely impacts the majority of you if you have rentals with tenants who are either going to claim that they can't afford to pay the rent or actually can't pay the rent. Let's go back to, does everybody, I know I can't really hear any of you, but does anybody have any questions about this right now? Let me look to see on the, well, we can come back to that, I guess. All right. Another important order in North Carolina in particular is the, let's see here. I must have gotten rid of it, but is the Governor Cooper's order in May. He entered an order, I believe, on May 30th that basically said, for any landlord, I don't care if you're a covered property, you've got federal funding, any landlord in all of North Carolina, you have to offer a 6-month payment plan, or let me rephrase, a reasonable plan, not less than 6 months for a tenant to repay their June rent. And so I know some of you probably have tenants that haven't paid, May, June, July, August, what are we, September now. And so I have not filed evictions based on June's rent because the governor's order, while I think it's incredibly unconstitutional, and if all of you want to band together and sue him, I'm all for it. You guys just need to come up with about $300,000, but I'm all for it if you want to do it. Because that exists and it's on the books, you can't go after somebody for June, and it really doesn't even need to be a part of the discussion. Somebody asked me recently whether or not, let's say that the person moved out, they either voluntarily vacated or you happen to get them out on an eviction for, August rent because it wasn't a covered property. Can you deduct it from the security deposit? And that's an interesting question. And I don't know that I've got the right answer on that. And I guess what I would say is you can't really deduct it from the security deposit unless it's owed. And I wouldn't say it's owed unless you've offered the 6-month payment plan to the tenant, and either they've rejected the payment plan and they said, no, thanks, I'm good, I don't need the payment plan, or, they've entered into the payment plan, in which case it certainly wouldn't be due anyway, but you could deduct, a portion of it because you would enter into it, and if they fail to make a payment, then you could deduct that. But for sort of general advice, if somebody owes their June rent, chances are they also owe July rent and August rent and now September rent. And so I would probably deduct July rent and then either not pursue the June rent or send them a 6-month offer to repay June's rent. The 6-month payment plan does not start, upon the entry of Governor Cooper's order. So I think a lot of people thought, well, it's out May 30th. They get 6 months from beginning, I think, July 1st-ish time period. And so it started automatically in July. That is false. It starts when you offer the payment plan. The June order, and I've got a printed copy here, and I'll just read it. it says residential tenants shall be provided the opportunity to make reasonable payment arrangements to pay off over at least a 6-month period any rent that became due in the effective period, which was just 21 days from May 30th to I think June 20th. And the 6-month payment period, well, it says the 6-month payoff period shall be calculated from the expiration of the effective period. However, when you go back to the first sentence, it says they shall be provided the opportunity. And so if they're not provided the opportunity, then the 6-month payment plan really hasn't started yet. So don't get confused by that last sentence. I think the way a lot of people and judges in particular are interpreting it is it's 6 months from when you offer it to them. So to the extent you have tenants who haven't paid June's rent, I would go ahead and offer them the 6-month payment plan and, you know, put some language in there that says, you know, that it's going to be due notwithstanding any other rental obligations, and you're doing it in conformity with the with Governor Cooper's order. And if you need, obviously, if you need help and you want to reach out, feel free. So that's important to know. The other thing that's important to know is that you can't charge a late fee for June rent. So even if you are not a covered property, so you're just any old landlord in North Carolina, you cannot charge a June late fee. And going back to the CARES Act, you can't charge a late fee for April, May, June, and July. So all 4 of those months, you cannot charge late fees. If you've assessed them, you need to take them off the ledger and apologize to the tenant if questioned about it, and send an updated amount that says, we've updated our records, and, you know, late fees were inadvertently assessed to your account, you know, automatically, and we've removed them in conformity with the CARES Act or the, you know, governor's order, whichever is appropriate. I know that it stinks because a lot of management companies, some of you have them, a lot of you collect your fees based on the the late fees you get. That's part of how you run your business, and I'm sorry for that, but that's unfortunately what the government has said. So quick recap: if you have a federally backed mortgage, federally insured loan, Fannie Mae, Freddie Mac, veteran, etc., no late fees for at least April, because the CARES Act became effective March 27. So April, May, June, and July. Interestingly, and I'm going to pull this back up, the new agency order that came out today very specifically says, and I'm going to try to find the language, very specifically says that I think you can charge, I can't find it right now, but you can charge late fees. Nothing in this order precludes the charging or collecting of fees, penalties, or interest as a result of the failure to pay on a timely basis under the terms of any applicable contract. So nothing was extended as far as late fees. So beginning in August, if somebody hasn't paid their rent, you can begin assessing the late fees. At least as of now, as we all know, this is a changing landscape. I've gotten a lot more gray hairs in the last couple months because every day there's brand new things that come out. But like I think I had 2 spring up today. But late fees are appropriate right now. However, this thing is actually very helpful in the context of the agency order, and this is going to be where I segue to the CARES Act. This particular order says that you can still evict. Nothing in this order precludes. So you can still evict tenants based on anything related to criminal activity, but only while on the premises. So engaging in criminal activity while on the premises. Some of you have leases that say if you engage in criminal activity anywhere, we can evict you. This is an interesting tweak here, and it says you can only evict them if they're engaging in criminal activity while on the premises. So if you have a criminal activity case, you need to pay particular attention to where the criminal activity occurred in order to be able to file an eviction. And for all of you who intend on filing evictions, I would strongly encourage you to do so through a lawyer. One thing I noticed in this, just to jump down, I'm sorry, I'm kind of all over the place, but something that is very important in this is that the CDC has said, if I can find it, where is it? Yes, criminal penalties. For all of you who violate this order, you may be subject to a fine of no more than $100,000. If the violation does not result in a death or 1 year in jail or both, a fine of no more than $200,000 if it results in a death, meaning if somebody is dispossessed as a result of an eviction that you proceeded on when you should not have, that person goes out into the community, dies as a result of COVID, and their estate comes knocking at your door, you may be fined $250,000. It's absolutely asinine. But again, my commentary is really not what any of you, or the government, let me rephrase, not what the government cares about. Okay, so back up to this other important information. I wish they had like a table of contents for this. All right, so we can evict people still for engaging in criminal activity while on the premises. If the tenant is threatening the health or safety of other residents, again, not persons. This is another, obviously the person who drafted this is not a landlord and has not reached out to the landlord community to get some insight here, but you might have a particular person who threatens the safety of the property manager. Well, the property manager isn't a resident. So again, pay particular attention to what exactly is occurring. It says threatening the health or safety of other residents. Damaging or posing an immediate and significant risk of damage to property. I don't know really how posing a risk of damage to property is how you're gonna win that in court. So I would just act as though that's not even there. Because how are you going to argue that somebody may damage your property? I mean, you're not going to win on that. So if somebody's damaging your property, then essentially that there's an exception for that. Violating an applicable building code relating to health and safety, or violating any other contractual obligation. This goes back to the point about your Staples leases. What you have in your contract is very significant, and if you've got an obligation in the lease that requires somebody to, for example, obtain renter's insurance, obtain whatever, pick a violation, something in the contract that, unauthorized occupant is another one. They've got a bunch of people living with them. That is another contractual obligation other than the timely payment of rent or similar housing related payments. So late fees, etc. So you can't evict for late fees, but you can charge them, and you can't evict for rent if the person provides you with that declaration under penalty of perjury that we talked about before. This is obviously brand new. They have not even, the CDC has not even published the paperwork to their website yet, as far as I can tell. And so I have a feeling that in the next, 5 days, this is going to be a pretty hot topic for news outlets. And you may even have some tenants start inquiring about it in the next, week or two. But I have a feeling based on what I've heard that this is going to go into effect within the next 7 days or so, if not less. Now, those of you who are thinking, let me go ahead and file my evictions, I would caution against that because I think that you might even have some people get them dismissed saying that, you can't pursue an eviction. And let's just go back up and look at this together because I think this is important. It says shall not evict a covered person. Well, we all know filing an eviction is very different than actually evicting someone. So for those of you who are like, let me rush out and file my 10 evictions right now and get rid of these people, let's say it becomes effective next week and you go to court, and before the judgment is entered, the tenant shows up and say, hey, here's my declaration. I expect that you're going to follow the CDC, and otherwise you're subject to a $100,000 fine. If you still ask for a judgment, then you're still trying to evict them. And so I think that there's really no point in trying to get around this if you fall under it. The positive news being you can rely on the tenant to provide you with the declaration. So if any of you have questions, I probably have the same questions, and I'm happy to, follow up if I learn any more, wonderful news about this thing. I'll try to send something out to Stephanie so she can send it out to TREIA, and you've got a little bit more information. But that's kind of the quick and dirty on what has happened in the last 6 hours or less. So I'm going to go back to, do we have a few more minutes, Leslie and Stephanie, or should I wrap this up? I don't want to go over our
Yeah,
time
you
limit.
take a couple more minutes, hon. If you got some more stuff. We're always interested in stuff.
Sure. I'm going to just briefly talk about the CARES Act because I think that's very important to know. And one of my clients is on this call, and actually probably several of you are on this call. Good to see you. Appreciate you joining. One of my clients had a very bad experience recently, and I feel very, very, very bad for that client because the CARES Act, which I'm pulling up right now, essentially says that if a residential, if you got a residential tenant and they're in a covered property, you can't, let's go down here, you can't, during the 120 days, make cause to be made any filing to recover possession of the dwelling unit for non-payment of rent or other fees. But down here, you've got this little section that says, the lessor of a covered dwelling unit may not require the tenant to vacate the covered dwelling unit before the date that is 30 days after the date on which the lessor provides the tenant with a notice to vacate, and you can't do it until after the 120 days. I'm going to try to shorten that language to say this section appears to be separate from this section. So legal aid and tenant advocates all across the country are arguing that while you can't evict for non-payment, you also can't evict for criminal activity or unauthorized occupant or anything else, because this section says you can't issue a notice to vacate until after the expiration of the 120 days. And so this particular client went to court. I'll give you the real short story. He would tell it much better than I would, and I'm sure in a much more animated way. But this tenant essentially was brought her boyfriend over. Her boyfriend didn't like my client when it boils down to it, and told him he was going to go to his car and get his gun and essentially come back and deal with my client. My client perceived that to be a major threat. He felt like he actually was going to get a gun and he was probably going to do something crazy. My client left the direct premises, contacted the police. This guy was drunk out of his mind, and the police basically, rather than addressing the issue, because again, I forgive my commentary, it's been a long day, and so sometimes I overstep here, but the police in Durham are not going to evict people right now. They're doing everything they can to make it difficult for landlords, and that's just the reality of it. And I'm sorry if you're an officer on this call, but that's just the reality. So the police showed up, and they didn't want to arrest anybody with all that's going on. And so they basically said, look, man, you're drunk. Let's just get you out of here. Why don't you leave? And you call an Uber and everything's squared away. So there's no arrest. So my client says, I mean, you can't threaten a landlord with a gun. I mean, this is outrageous. So he essentially files an eviction, and legal aid shows up at the hearing and says, oh, no, look at the CARES Act, Your Honor. I know he couldn't evict for non-payment of rent, but he couldn't really evict for this either, because he has to send a 30-day notice related to the criminal activity. Guess what? The case was dismissed. And, I'm not going to go into all the sort of strategy about what we're going to try to do to handle this, but this is a recurring theme, and their position is that really at any point in time, indefinitely, you have to give a 30-day notice for anything, including rent, in order to evict somebody. The one very unfortunate thing about this CARES Act is that there's no sunset period. There are sometimes the legislature will pass an act and they'll say, look, this is effective from this date until this date. Much like this agency order, which when you go back and read it, I can't find the specific language, but it basically says this order is in effect through December 31st. And there's a sunset, a definite date on which it expires. The CARES Act, unfortunately, does not have a sunset. The wonderful, I'm sure incredibly brilliant people who drafted it forgot to put a line that says this is only effective for 150 days, which is the 120-day period here, plus a one-time 30-day demand letter for non-payment of rent. But they didn't say 30-day demand for non-payment of rent, and they didn't say that this had to be a one-time notice. They just said, you got to send a 30-day demand to evict anyone, and that's just how it is. And so Legal Aid is interpreting this act extremely broadly. I have no doubt that in Durham County, you will lose every single eviction that you file if you do not provide a 30-day notice. So I think I said this at the last meeting, do not buy property in Durham. I hate to not help that market, but if I'm helping you guys, I would tell you not to buy property in Durham. It's a horrible idea. If you intend on flipping it, make sure there's not somebody in there. I'm sure Stephanie would have a lot of commentary on that one. But if there's no one in the property and you flip it, you get out of Durham, no problem. Well, I'm sure there will still be some problems, but you know what I mean. Not a relatively easy situation. If you go into Durham with the expectation of renting and making money, I'm going to tell you right now that is not going to be a good short-term solution. If you think you can withstand $20,000 of legal expenses and lost rent in the next 12 months, and you still think it's a good deal, then go for it. But right now, Durham is a really bad idea. In Raleigh, I will tell you that I'm going to chance it with some clients. People who don't pay their August, or let's say we'll just use September. Somebody doesn't pay their September rent on time. Well, I'm going to act as though this CARES Act is over, and we're just going to see what the courts do with it until the court tells me differently. Now, the risk is that could be unfair and deceptive. It could be a whole lot of things. But I know one law firm in the state is telling clients they're not going to file unless you give a 30-day notice for rent at any point in the future until the government says otherwise. And I used to work at that law firm. I'm not saying anything bad about those attorneys, but I just think that that is preposterous. I think that is not what the government intended, and I would do something different. Now, that my commentary on that is a little bit overshadowed by the agency order that was just put into place. So if you receive declaration paperwork from your tenant, you're not going to be able to evict anyway. But if you don't receive declaration paperwork from your tenant and you decide you want to evict, then I think it's worth challenging. And I'll also show you this memo briefly, and then I'll try to wrap up because I'm sure probably many of you want to eat dinner. There was a memo published by the Administrative Office of the Courts. Don't ask me where I got it, but I somehow got my hands on this thing. And I think it's incredibly helpful. They basically are telling, magistrates, district court judges, and clerks. This goes out to everyone in the state of North Carolina. They are saying, we think that the 30-day notice to vacate. Let me see if I can find it. If the initial default in the rental payment occurs after the moratorium, meaning August rent is not paid on time, they think the notice to vacate is not required, which is consistent with what my position has always been. And I think I'm going to chance it in Wake County. I think a lot of the judges in Wake County are going to honor this. Legal Aid is arguing that this is pure speculation. It's not law. The judge has to interpret the law. However, I do think this is really good guidance, and that's why I think I'm kind of willing to challenge it, knowing that obviously, it's the client's decision, and some of you may decide I don't want to chance it. I'd rather send 30-day notices indefinitely. And again, if you receive a declaration, you can't evict anybody right now. Now, this doesn't say you can't send them reminder notices, and so I think it's appropriate to send a reminder notice to your tenant if they haven't paid. Let's say, September 1st, let's say it gets to be September 8th and your tenant still hasn't paid. You just go about your normal business, provided you're not a covered, property. And even then, I still think you can. And, let's say in response to your late notice, you say, look, we're sending out the late notice. You got to pay your rent. If you don't pay it within 5 or 10 days, we're going to evict you, which some of you have to, send a notice. Some of you don't, depending upon the language of your lease. another reason why lease is very important. And so let's say in response to that, you get the declaration, then obviously you don't evict. And then maybe you work out a side, an agreement with the person. And again, I would make sure it's carefully drafted by whether by me or some other lawyer, an agreement that basically says, we agree that we're going to make partial payments, and that if I don't pay the partial payments and, I don't otherwise fall under this act, and if for some reason I can afford, my rent, we believe you have the ability to proceed with an eviction, whenever it becomes appropriate, if you don't have language that allows for partial payments. So just some other food for thought as you kind of navigate this. So we may need, Stephanie, we may need to, if you guys want to do another one of these in another, month or two, depending upon how things change in the next couple of months, I'd be happy to hop back on for 30 minutes or so, or the hour, whatever you want, to answer some questions. I think we're running out of time, but Leslie, if there are any questions that I can
I've
quickly
got
answer.
one question for you, Stephanie, from David Kirsch. She said, how likely is it that the CDC rules won't be enacted? In North Carolina, we typically needed a 10-day notice to pay or vacate before you could file eviction paperwork. The CARES Act 30-day rule would mean that the normal 10-day notice now needs to be 30.
Yes, that is exactly why I think it's absolutely preposterous. And I think that you just go about your normal business. But again, that's a risk that you're going to have to take. I mean, the downside is if you don't send a 30-day notice, if you're in Durham, I'm just going to be honest with you. If you're in Durham and you have a tenant who's not paying in Durham, just send the 30-day notice. You lose 20 days, but you gain a winning argument when legal aid shows up and says, if they show up and they say, oh, they never sent their 30-day notice, and you're already 30 days into the eviction because it's taken them 30 days to schedule an eviction these days, you've lost a lot of time. So while it's probably going to kill a lot of you, I would, if you are in Durham, I would send a 30-day demand for non-payment. Just be aware you may still get some of these, declarations, in which case you're not going to be able to evict.
Yeah.
And remind me, Leslie, what was the first part of that question?
Is there any, how likely is it that the CDC rules won't be enacted?
I think they will be published very soon, and I think there may be some constitutional challenges to them, but I think they're going to be put into effect pretty quickly. I think it's likely, or I guess unlikely, that they won't go into effect.
Okay. David says he's in Wake County. Would that make a difference, county to county, or no?
Again, my position has been the CDC agency ruling applies to everyone. It applies to any landlord, anywhere, regardless of whether or not you have a covered property. And so if you are a covered property, let's start with that scenario. You have a federally backed mortgage. If the only rent payment that they haven't paid is August and now September, and you're in Wake County, I would probably file anyway and see what happens without the 30-day, because it's after the expiration of the CARES Act, or what would have been or should have been the expiration of it. And we just chance it and see what happens. Because what the magistrates and judges are going to be looking at is this. They're going to look at the memo from this not school of government. I think they have one that's similar, but this is the administrative office of the court. So I think if you're in Wake County, if it were me, I'd probably chance it and file. I'd probably go through an attorney just to make sure that you've got an attorney who's going to be able to, again, me or somebody else, I don't care who it is, make sure you have a lawyer who's going to be able to go in and articulate, hey, look, Judge, here's a copy of this memo. Here's, this is what the CARES Act was designed to do, et cetera. And you make sure you get the right legal arguments, and I think you chance it in Wake County. If you lose, worst case scenario, I think you lose, and you got to start all over and send a new 30-day demand. That's why I think it's worth it. If somebody tries to say it's unfair and deceptive, I would call absolute BS on that one, and I would say, well, then why did the administrative office of the courts tell everyone otherwise? Your Honor, here is a memo. My client was following the directives of this memo. Even though it's not law, there was clearly a good faith basis. I think unfair and deceptive is absolutely crazy. But, what do I know? I'm not a judge, not a jury. So that's the best legal advice I can give. So to answer your question, Leslie, or whoever asked Leslie that,
That
I
was
do
good.
think it is dependent upon the county. I know Legal Aid in Durham has like 20 some lawyers who focus specifically on evictions. They're trying to deter every eviction in Durham. Wake County is understaffed. They just recently changed their management. And I think they're going to have less representation in Wake County. Not to say that you take advantage, but I think you push the envelope and say, look, this is preposterous. Look at what our administrative office of the courts is saying. You know, look at the actual text of it. It's crazy, Your Honor. And I think you're less likely to prevail in Wake County. But, you know, again, the downside is you just have to start all over, and you know, you might make some case law. So.
Okay.
The other thing I
James
would
is-
just quickly mention, and again, I know we're running low on time here, so I'll finish up with this, maybe
Okay.
one more question. There are going to be a lot of district court appeals, and you guys need to get ready for it. Your tenants are going to appeal. Always, there has been an ability of a losing party, most likely the tenant, to appeal the case from small claims court to district court. I file all my small claims cases, you know, or evictions in small claims court. You automatically have a 10-day right to appeal. You don't have to be at the hearing. You don't have to have a defense. You can just try to buy some more time, really is what it boils down to. And you show up, you file your paper, you claim you're an indigent, you pay a small prorated amount for the month you're in, and you pay your rent to the court going forward, and you get an appeal in district court. A lot of tenants are doing this trick where they are, they're requesting jury trials, which are not going to happen for, you know, 6 months or a year. And so they're trying to delay it as long as possible. You know, I've got some lawyer tricks I can do. We can do summary judgment. We can do a couple of motions. You know, essentially more and more tenants know about the appeal process. They're way more advised of their rights than they ever have been because they've got their phone right at their fingertips. And so you expect appeals. If you're a company, back to what James was saying earlier tonight, if you have a corporation, an LLC, or really anything, any kind of corporate or business entity in North Carolina, you have to be represented by a lawyer at the district court level. You can go to small claims on your own, but you have to be represented by a lawyer in district court. So I'm sorry to tell you that, but a lot of you are probably going to have more appeals than you've probably ever had in the past just because of what's going on. So I'll take one more question, Leslie, if you want to.
Okay, James just wants to know, good or bad, Cumberland County, Fayetteville market. That's real popular. There's a lot of landlords up here. You know, a lot of people are buying down there. It's not that far, but it seems to be a hot market. So
Yeah.
have you heard anything about what's going on down there?
You know, I haven't heard one way or the other. Durham is a historically tenant-friendly market. Wake County is relatively moderate, but I would say, you know, not overly tenant-friendly, and I think not landlord-friendly, but certainly not landlord-adverse. Cumberland County, in my prior experience, I used to go there all the time for evictions, you know, 5 years ago, and you know, I think they generally are in the middle. You know, they don't want to screw the landlord over, but if there's a good argument where they can keep somebody in property, you know, they'll do it. So I think more landlord, not landlord adverse, but not tenant friendly. So again, I wouldn't go to Cumberland though, or really any county, without a lawyer, even in small claims court, for these evictions in the next 6 months to a year, depending upon when you can file. And I would talk with a lawyer. If you don't have an attorney who at least you can, you know, like I have a lot of my clients have a general file open for them. So they'll call me and they'll say, hey, you know, I bill at $300 an hour. So they'll call me and we'll talk for, you know, 30 minutes and I'll bill them for half of an hour's worth of time. And they'll ask me a bunch of questions and then they get the answer. Call a lawyer before you go to file an eviction because there are too many laws, too many agency rules, too many, I can't even fully keep track of everything that happens because there's something new every day, but I try very hard to stay on top of it. And I promise you, I'm going to be able to help navigate it better than you would. And you're going to want a lawyer to kind of, you know, rely on when making those decisions. And I might tell you, look, I know you think you have a good one, but bad case, bad idea. You're going to spend $15,000 in litigation, just drop it and send the 30-day demand. Other ones I might say, you know what, let's chance it, low risk, let's make this happen. So if I were you, I'd consult with an attorney before filing an eviction in this landscape.
Great advice.
So
Alrighty.
any other questions for James before?
Nope, that's it for questions. And you are an absolute font. You're amazing. But anyway.
Thank you so much. You did a great job as usual.
Seriously, you're right. Things are changing so fast. We got to keep up on it, and we will definitely in the next few months we definitely need to get you back if the scenery changes and we start hearing things. We'll definitely get you back to maybe give us an update on if they're extending or if they've changed anything. It's always good to know. You need to be informed for sure.
Sure.
And Stephanie, enjoy your 2 days because it sounds like you.
Yeah, I definitely need a couple day vacation. So,
Yeah.
and if I don't know if any of you need, like, if you need my email, if you want to set up one of those general files and you want to, you know, if any of you need counsel, just email me and we'll get that set up. You can pull up my email on the website. Same with James. If any of you have closings, I realize I may be biased, but I think he's a great closing attorney. He did my closing, and he's a great guy. And if you just email us, just shoot an email over, and we'll get you set up. And then even if you don't end up having questions, at least you've got a lawyer who you know you can contact in the event something does arise later. So
Okay, we'll send out a general email to all the attendees of the meeting with yours and James's email address. Stephanie will make sure that goes out and everybody's got that on file so they can touch base with you if need be.
that sounds perfect. Well, it's very nice to. I hate that I can't see all of you, but it was very nice
So shy.
to meet you through this wonderful thing we call Zoom. And I appreciate the opportunity to speak, and I'll look forward to talking with some of you offline at a later date. So,
Thank you so much. We appreciate it.
Thanks,
I'm
Stephanie.
gonna
Thanks,
log off unless you need
everybody.
anything from me.
Stay
Have a good evening.
safe.
Thank you.
Bye.
I'm gonna stop share. There we go. All right, y'all have a good one.